Have you been retaliated against? Let's talk about that. Welcome to Gateway to the Law, your go-to channel for demystifying California's legal maze. I'm your host and partner at Gateway Pacific Law Group, Roger Haig. My assistant Marcus will also be helping me throughout this video. And whether you're just curious or seriously considering legal action, you've come to the right place. This video is not legal advice. It's meant to be used when you think someone has violated the law, but you don't have enough information to decide whether or not to call a lawyer. Then, our videos are a great starting point for you. We break down complex laws into easy-to-understand, bite-sized chunks, helping you decide if it's time to reach out to an attorney. So sit back, relax, and let's talk about some California laws that protect whistleblowers. Marcus?
Thanks, Roger. There are a lot of state and federal laws that protect whistleblowers. But in this video, we're just going to talk about 4 California laws that protect employees. Some employers are going to appreciate an employee who does this and correct whatever is being reported. These employees aren't going to need legal protection. On the other hand, some managers and supervisors are going to do various things to silence or retaliate against an employee who tries to do the right thing. We call these things adverse employment actions.
Or worse.
Well, assault is an extreme adverse employment action, but we'll talk about other examples later. We'll also talk about some specific things you should do if you are a whistleblower to help you prove your case.
First of all, let's talk about California's Fair Employment and Housing Act, also called FEHA. FEHA stands out as one of the strongest employee and housing protection laws nationally. There's an entire section that deals with protecting renters and buyers of housing. But in this video, we'll focus on the section that addresses just on employee rights.
That's right, Roger. FEHA makes it against the law for employers to discriminate, harass, or retaliate against employees who are within certain protected categories. These include, but aren't limited to, race, religion, disability, sex and sexual orientation, age, but specifically individuals aged 40 and above. Some examples of protected activities include, but aren't limited to, reporting instances of discrimination and harassment, participating in investigations, and being a witness for someone whose rights under the FEHA were violated.
Before you can assert your rights as a whistleblower, you have to show that you have been retaliated against. This is also known as an adverse employment action. Adverse employment action is broadly defined to include any action or decision taken by an employer that negatively impacts an employee's job performance or opportunities. Now, the parameters for what constitutes an adverse employment action are pretty broad. An easy example is termination or firing, but other examples could include but are not limited to, well, Marcus, give us some examples.
Sure, Roger. Negative performance evaluations, harassment, forcing you to retire or inviting you to resign and excluding you from training opportunities. Consult with an attorney because there's a lot more examples.
It's key to remember that not every bad or upsetting thing that happens at work counts as an adverse employment action. For an action to be considered adverse, it really needs to make a big negative change in how you do your work or your job situation. Also, it's not just about one thing that happened. Usually, we have to look at everything around what happened, the whole situation, to decide if something is truly an adverse employment action.
Next, let's talk about Labor Code Section 98.6, which prohibits employers from retaliating against employees or prospective employees for exercising any rights under the Labor Code. This includes a range of activities including but not limited to filing or participating in a complaint with the California Labor Commissioner, participating in political activities outside of work, or being involved in a civil suit against your employer to obtain your unpaid wages, and refusing to perform work that you believe is unsafe or illegal. California Labor Code Section 98.6 serves as a vital shield for employees, safeguarding them from employer retaliation when they exercise their rights under the Labor Code. And there are a lot. From being permitted to work in a safe work environment to being paid lawful wages. This law broadly protects employees, so if you feel you have been retaliated against as an employee, there's a good chance California Labor Code Section 98.6 may apply to you.
Next, let's talk about another powerful whistleblower law that provides broad protections to California employees. Labor Code Section 1102.5. Now, there are a lot of parts to this law, but essentially, it protects employees who report violations of local, state, and federal laws by their employers to government agencies and even reports and complaints made within the company. So, say an employee sees something that they think is illegal, and they report that to somebody like a supervisor, a manager, corporate officer, or even a company executive. If they're retaliated against for that, Labor Code Section 1102.5 could apply to them. And here's the kicker. The employee doesn't have to be absolutely correct that a violation of a law has occurred. They only have to have a good faith belief.
That's right, Roger. Instead, it's all about the sincerity of their belief. As long as they genuinely believe that there's a violation happening, even if they're mistaken, they're protected under this section. Quite a safety net. Right? To prove a retaliation claim, under Labor Code Section 1102.5, the employee must first show that they engaged in a protected activity, such as reporting a suspected violation of law or testifying in a proceeding before a government agency. Next, that the employer knew about the protected activity. And finally, the employer took adverse action against the employee for engaging in that protected activity. In October 2023, California Governor Gavin Newsom signed into law AB 497, which expands anti-retaliation protections for employees in two of the laws we talked about, Labor Code Sections 98.6 and 1102.5. Essentially, it starts with the assumption that the employer retaliated against the employee if the employer took adverse action against an employee within 90 days of the employee engaging in protective activity. Violations of the new law carry a civil penalty of up to $10,000 per employee, and AB 497 makes it even more financially painful to violate Labor Code Sections 98.6 and 1102.5, because attorney's fees can be very high if these cases are litigated to trial or arbitration. So there's a strong incentive not to retaliate against these whistleblowers. Next, let's talk about California Labor Code Section 1019. Regardless of how you feel about illegal immigration, the fact remains that thousands of California employers employ unauthorized workers. California tries to protect these workers from unscrupulous employers by extending to them some legal protections under California's Labor Code. Labor Code Section 1019 makes it unlawful for an employer to engage in an unfair immigration-related practice against an unauthorized worker because the employee was trying to enforce their rights under California's Labor Code. An example of a violation of this law would be if an unauthorized worker complained to their employer that they were not being paid overtime or the proper minimum wage, and the employer threatened to contact immigration authorities. The simple rule is, if your employer is threatening to reveal your immigration status in order to buy your silence, that's illegal, and it could be very expensive for the employer and beneficial to you. Before we move on, if you like what you see and you want to read more information on laws that affect you as an employee or consumer, go to the video description on this YouTube channel. It has the link tree to all our social media channels. It also has a link to our website, which has blogs about various employment law-related topics and even helpful documents like checklists to download. Also, consider hitting that like button and writing a comment. It helps us grow the channel so we can get helpful information to other consumers and employees. And if you wonder why people are always asking you to hit the like button, it's because it helps bump up the video in the search results, so more people are likely to watch the video. So you've seen something you believe is unlawful, illegal, or unsafe. What should you do? First, always make your complaint in writing, preferably by email, so you can BCC yourself. An email reveals the person you made the complaint to, the date of the complaint, and the substance of the complaint. If you are complaining about something that might implicate privacy concerns for third parties, such as HIPAA, or reveal proprietary information, don't reveal the identity of that third party in the email, or reveal specific proprietary information. Write the email in general terms, but with enough detail so the subject of the complaint is clear. If there are company documents that you believe prove your case, there are issues that must be considered. Consult with an attorney about what you should do. Request a copy of your personnel file, and make sure you get a copy of your performance evaluations and pay records, official job description, and any emails or accolades that you've received about good job performance. If you win a claim for retaliation, you may receive back pay, front pay, missed bonuses, and reinstatement if you've been fired. In many cases, you may be entitled to have the employer pay your attorney fees and costs. You can possibly receive emotional distress damages as well as punitive damages to punish the employer for doing what it did.
California's anti-retaliation laws protect employees from being punished for speaking up about wrongdoing or just exercising their rights. If you believe that you've been retaliated against by your employer, you should contact an experienced employment law firm, like Gateway Pacific Law Group. An experienced lawyer can go over the facts and discuss your options. Don't forget to visit our channel description for information about our social media platforms and our website, where you can find our blog articles on various summaries of employment and consumer laws, as well as helpful forms and checklists. I'll leave you with this. Law is the compass of society, guiding us to justice. Until we meet again, stay true to your course.